Thank you, Russell. I hope I'm not going to do anything with the PowerPoint now, because I'm not using a PowerPoint. And those of you who remember the 1992 vice presidential debate, I am Admiral James Stockdale. Why am I here? I'm not a litigator. I'm the one who drafts these terms and conditions. Oh, this looks good. This will protect my client. Let's add it. We'll make it a little bit longer for the benefit of the clients. The reason I'm up here is because there have been instances involving clients of mine and others clients where the use of email, and worse yet, the instant messaging and the texting has given rise to what I've called in the article that you have in front of you the inadvertent contract. The short piece of advice is to proceed with caution whenever communicating additional terms and conditions that you'd like to propose to a standard contract. These terms and conditions used to be the fine print, and now sometimes you accept these terms when you click, when you go into a vendor's website. It comes up in so many common contexts. The real estate broker who has an addendum that he puts before the buyer and the seller, and one party says, yeah, this in an email, yes, this looks good. I'll pay you $50,000. I'll pay you $50,500, to beat the competing bidder. But I want my lawyer to look at it, and there'll be additional terms and conditions and a rider. Well, a court has said, an appellate court, a case coming out of Summit County, said no. Once you have expressed your assent, once you have told the other side, yes, these are the terms, whatever additional terms and conditions and riders you may want to suggest, that's down the road. But you have an agreement. The email itself constitutes the acceptance, and whatever your lawyer may choose to add, is going to be proposed additional terms and conditions. With just a stroke of the keyboard, the terms of a contract that you or your counsels carefully negotiated and drafted can change. There's a case, a federal case, that you'll see in the article coming out of the Southern District of Florida, where someone was being compensated based on sales leads. The original contract said maximum 200 leads per day. That's the limit to which you receive commissions. But there was a back and forth. Someone was away from his office, and when the person came back, he saw 2,000. It wasn't a typo. The sales agent said, I can sell 2,000. And the reply was, that's great. Contract. And the argument that there's a written contract saying that this is the entire agreement, any modification must be in writing, that didn't carry the day. It didn't carry the day because the communication of the offer, combined with the fact that there was a signature block indicating a writing, was enough to modify the contract. Basically, the court there overrode the entire agreement clause. A lot of lawyers and their clients sort of latch onto this, some people call it an integration clause, an entire agreement clause. No amendment is effective unless it's in writing, signed by both parties, or signed by the party against whom the obligation is being enforced. Well, there are obviously ways around that in the eyes of several courts, and this is an emerging body of law. The email itself constitutes the writing. The signature block is enough in the eyes of some of these courts to authenticate the document. That is the written instrument. I've drafted and I've looked at email disclaimers for the benefit of clients, a sample of which is before you this morning. This was for a manufacturing client, but it easily can be adapted for other types of businesses. And the email disclaimer it's a wonderful thing, but it too can be overridden by inconsistent action. If an agent, for example, has apparent authority to bind the principal. That's enough. There's a case coming out of another federal court where an insurance agent said, you don't have to put the insurance carrier on formal written notice. You've told me that's enough for you. I'll take it from there. The policy itself said you must prepare a written notice of claim. That wasn't done, and the claim itself, when the insurance company tried to deny the claim, relying on the language in the policy, the court said, no, your agent had apparent authority, and he said in an email it was okay to send it just the way you did without a formal notice to the carrier, and that was enough. The email disclaimer that we provide actually has been very helpful to a few of our clients. There's a lot of back and forth that goes on. Everything that Russell has shared with you in the past 20 minutes, that's still the set of rules that governs even the electronic communications. But courts have found it necessary to interpret them and apply them in the age of instantaneous communication, and it's created some odd results from time to time. And again, be very cautious when you receive an email that proposes to amend terms and conditions, whether it's a change order, whether it's a quote or a proposal, a contract, a proposed rider to a contract. You need to make it very, very clear that your response does not constitute acceptance. You can take it under advisement. You'll talk with your attorney. Thank you very much for the proposal. Anything that doesn't rise to the level of acceptance. And I'm sort of the sorbet. We have two main courses today. We have Russell, and I did the math. I actually am in my 30th year of practice. Sorry, Peter. But this reminded me of one of my law school classes, a refresher on UCC Article 2. And the second course is Ron Friedberg, and I'll turn the podium over to him.